Today's hearing, we're going to examine the consultation process that takes place pursuant to Section 106 of the National Historic Preservation Act, or NHPA. Congress enacted the statute in 1966 to ensure that the federal government would give due consideration to preserving America's historical artifacts with appropriate stakeholders. This section of NHPA is itself purely procedural, and as such, it requires government officials to undertake a specific process but doesn't mandate any specified outcome. In that regard, it's similar to the National Environmental Policy Act, or NEPA, which directs a process, not a result, and which the Supreme Court recently, in its 7-county decision, returned to a right-sized role in federal policymaking. Today, we'll consider the scope of Section 106 of NHPA to ensure that it plays the role that Congress intended when NHPA was enacted. We'll be hearing from 3 witnesses today to better understand these issues. They are first, Dr. Chris Merritt, the State Historic Preservation Officer for the state of Utah. Second, Mr. Andy McDonald, the Environmental Compliance Manager for Montana-Dakota Utilities Company. And finally, from Mr. Stephen Concho, the Tribal Historic Preservation Officer for Pueblo of Acoma. Welcome to each of you. When a law written to protect our past starts to block our future, it can be worth examining where we are and how we got here and how we might find a better balance and a better way forward. The National Historic Preservation Act was written in 1966 to prevent places of genuine historical value from being wiped out before anyone even had the chance to speak up or to identify a relevant consideration. Few, if any, would dispute that purpose. We ought to protect the places that show where we came from and who we are. But over the years, a narrow procedural safeguard has evolved into a sprawling, unpredictable process that now delays some of the very projects our country needs to build and maintain that story. Section 106 has within it a consultation process that has become more like a maze without a map. Agencies, developers, and even preservation officers often don't know where the boundaries lie or how long the path will be. That confusion is showing up all over the country, and the uncertainty it sows has consequences for everyone. The Royal Slope Solar Project in Washington is now 3 years behind schedule. The Bonanza Solar Project in Nevada has been under construction for nearly 3 years. The Cape Wind and Vineyard Wind projects in Massachusetts each faced long delays before they could move forward. The Great Lakes Tunnel Project in Michigan, which would improve an important energy link across the upper Midwest, has spent years caught in back-and-forth reviews. Ironically, this project began because the state insisted the existing pipeline was unsafe and that it needed to be buried for protection. But once the tunnel was proposed, the area of potential effects, as the statutory language directs us to inquire into, it became so broad that every step triggered a new consultation. That in turn broadened the scope, and the broadened scope has added roughly 4 years to the schedule of the project. In Oregon, the Department of Forestry used most of its planning funds on heritage surveys required under Section 106. Instead of the wildfire work, those dollars were meant to support. These are not just the priorities of one particular political party or another that we're talking about. This affects projects all over the country, supported by people of many, many different backgrounds. They include solar and wind projects that my friends on the other side of the aisle would very much like to move forward, and yet they all run into the same consultation process that has grown so broad and at times inconsistent that it hinders and in some cases outright blocks projects, even though they may enjoy support from both political parties and from people at every point along the ideological continuum. My home state of Utah has shown how we can recalibrate and achieve a balance acceptable to everyone. Our state Historic Preservation Office has digitized records, created clear expectations, and kept consultation moving efficiently. Utah protects what is genuinely historic while allowing much-needed projects that will benefit its citizens to move forward in a timely manner. A law meant to safeguard our shared national heritage should not become an instrument of paralysis. Congress can preserve what's worth remembering without turning every permit into an archaeological expedition. The purpose of this law is and was always to protect what matters, not to make action impossible. Preserving our heritage should help us build wisely, but it should not and must not keep us from building at all. That is the balance this hearing is about. That's the type of balance we're hoping to be able to find, exploring ways to protect the story of where we've been without making it impossible to build what comes next. And now the chair recognizes the ranking member, Senator Heinrich.
Thank you, Chairman. The National Historic Preservation Act says something very simple. Before we build something, we should know if there's an important piece of our nation's history or culture in the area that we're planning to build. And if there is, we should try to figure out if we can avoid damaging it. Sometimes damage can't be avoided, and sometimes the project being built is important enough that damage to a historic resource is a trade-off that we choose to make. The NHPA allows for that, but we should at least check before we do irreversible damage to our national heritage. We can and must build the energy infrastructure our economy and our climate need while also preserving our history and our heritage. We can do both. Our kids and our grandkids deserve to know where they come from, and we can't tell the story of our nation without protecting the places that literally tell those stories. Sometimes those places are a historic building or a historic district. Sometimes those places are a valley or a mesa or a mountain. In my state of New Mexico, Mount Taylor dominates the horizon of central and western New Mexico, rising 5,000 feet from the desert below to a peak of above 11,000 feet. It is visible from nearly 100 miles away, and it is sacred to at least 8 tribes in New Mexico and Arizona. Mount Taylor and its surrounding mesas are a traditional cultural property, and the impact of development on it should be carefully considered before permits are issued. And that's what the National Historic Preservation Act requires. Without the NHPA, federal agencies could allow new development on this mountain without ever considering its impact on the religious practices, the traditions of neighboring tribal communities. Mount Taylor is listed on the State Register of Historic Places as a traditional cultural property, and that means that projects there get more scrutiny than other places in our state. But that's as it should be, because of the significance of Mount Taylor to communities across our state. There's no perfect law on the books, and we should always look for ways to make processes like Section 106 consultation more efficient and more effective. I'm confident we can do that while also protecting the places, even the stories that have forged our national heritage. I'm equally confident we can't do any of this without staff at the agencies that process permits for projects on federal lands. Our public land agencies have already lost more than 20% of their staff to early retirements, buyouts, and we're expecting layoffs at the land management agencies in the coming weeks that will make this even worse. It doesn't matter what kind of permit you're looking for, whether it's oil or gas or grazing or road construction or recreation. If the desk your permit application has landed on doesn't have a human behind it, you're not going to get your permit. We can tweak and reform laws all we want, but fundamentally, until we have adequate staff at the agencies that process permits, we will continue to see frustratingly long permitting times. And as I have said a number of times now, we can't do permitting reform if the administration persists in ignoring the fundamental laws. That's just as true for Section 106 agreements as it is for oil and gas permits. We absolutely have to fix these issues alongside process improvements if we're serious about permitting reform. And finally, I would point out that there are 3 buildings in this city that the National Historic Preservation Act does not apply to: the Capitol, the Supreme Court, and the White House. And we've all seen what is going on at the White House right now to our house. I look forward to hearing from today's witnesses about these issues, and I'm incredibly pleased to introduce Mr. Stephen Concho from Acoma, Pueblo, New Mexico. Mr. Concho is a member of the Pueblo of Acoma located in the western part of our state. He has served for nearly 15 years now in the Pueblo's Office of Historic Preservation, including the past 5 years as the Pueblo's Tribal Historic Preservation Officer, or TIPO. Mr. Concho also represents the Four Corners region on the Board of Directors for the National Association of Tribal Historic Preservation Officers, where he advocates for the protection of tribal cultural heritage and the advancement of tribal preservation programs nationwide. In his role as TIPO, Mr. Concho is dedicated to ensuring the protection, preservation, and continued vitality of Acoma's ancestral lands and the broader Acoma cultural province for future generations. His work emphasizes both safeguarding sacred places and promoting meaningful tribal participation in federal and state preservation processes. He's passionate about community education, strives to inspire younger generations to pursue careers in archaeology, anthropology, and cultural resource management, ensuring that the work of preservation continues under future Acoma leaders. Welcome, Mr. Concho, and thank you to all of our witnesses for lending us your expertise this morning on this incredibly salient topic.
Okay, we're now going to hear from our witnesses today. Let's go, we'll hear from each of you in 5-minute rounds. We'll start with you, Dr. Merritt, and then go to Mr. McDonald, then Mr. Concho. You may proceed.
Thank you, Chairman. Thank you, committee. I'm honored to be here today. I'm Dr. Chris Merritt, the State Historic Preservation Officer for Utah. I'm excited today to talk briefly about the National Historic Preservation Act. I've been a professional archaeologist for over 20 years, with the last 13 serving the great state of Utah. Every day I'm excited to go to work and share my passion for history. But let's first start with a small history review. The 1950s and 60s witnessed large federal initiatives such as interstate highways and urban renewal. Few checks existed, and because of this, many historic downtowns, neighborhoods, and places of archaeological heritage were unnecessarily destroyed with little to no consideration. This changed in 1966 with the passage of the National Historic Preservation Act, which, in part, mandated that federal agencies take into account their actions on historic properties. As expressed in the preamble of the Act, Congress found that, quote, "the spirit and direction of the nation are founded upon and reflected in its historic heritage," end quote. The Act established a federalist approach to historic preservation, empowering each state to create its own office to coordinate federal reviews and activities, the State Historic Preservation Office, or SHPO, later TIPOs. Creation of SHPOs was recognition that there needed to be a voice at the state level to review projects and offer local advice and technical assistance. While the Act created many programs, my comments today focus on the legal compliance process known as 106. From the Act emerged a regulatory process that starts by determining if an undertaking has the potential to cause harm, then identifying historic properties within the area, assessing those effects to historic properties, and finally resolving effects when necessary. This process can be broadly compared to the development of an environmental analysis under NEPA. There are many technical aspects of this type of review, but ultimately this is a procedural law meant to have a beginning and an end. The Utah SHPO knows that this process should be clear, reasonable, and as predictable as possible for not only the good of the agency and proponent, but also for historic properties themselves. Ambiguity in the scope, procedures, and timeline in a Section 106 process could endanger historic properties by dedicating insufficient time and resources to appropriately plan for these properties and could needlessly make them a perceived roadblock when expectations could have been clear at the beginning. We work through the process and move forward undertakings while still ensuring that historic properties are protected. My team reviews about 1,500 federal undertakings per year, ranging from mineral exploration programs to large-scale post-wildland fire rehabilitation. But only 3.2% of those result in adverse effects, illustrating that the vast majority of undertakings don't harm historic properties. SHPOs have 30 days to review projects, but we have a goal with our governor's office and legislature to cut that in half, and we regularly cut review times by over 75%. We have accomplished the feat of obliterating regulatory review timelines by not just commitment of dedicated staff, but investment in digital workflows. With the support from the governor and the legislature, we have been paperless since 2017, and one of the first SHPOs to do so. This builds on our comprehensive digital database containing 270,000 historic resources, nearly 50,000 inventories, and adding another 5,500 resources per year. And while those numbers are large, only about 9% of Utah has been inventoried. We share this comprehensive information with all federal and state agencies and consultants. In my tenure with the SHPO, we have focused on the reliability and predictability of Section 106 by working to create interagency uniformity, such as a standard-setting agreement with all 5 Utah National Forests. We also have nearly a dozen programmatic agreements with federal agencies that streamline the process, and we just signed a first-of-its-kind agreement with the Army Corps of Engineers just last week. There are times of concern, however, where national-level streamlining agreements can go too far. At the end of the last administration, the Advisory Council on Historic Preservation proposed a program comment that would have weakened or even removed state and public reviews of only those types of undertakings that fell underneath deeply politicized categories. Thankfully, that proposed program comment did not carry over at the administration change, but it had the potential to destroy the federalist approach to preservation by picking winners and losers based solely on the undertaking. Other issues with Section 106 can arise when the regulations are stretched beyond reasonability or misinterpreted, or by abusing procedural regulatory statements to unduly delay projects that receive SHPO concurrence. For example, one SHPO finds that a grazing allotment fence restringing is a simple matter of a letter, while another finds that the entire adjoining 100,000-acre allotment needs inventory and necessitates creation of an agreement document that could take months. There are always opportunities to do Section 106 better, and I'm personally hopeful that the model we employ in Utah can demonstrate where efficiencies and streamlining improve the process for all involved parties. Empowering the states to be at the center of this process is a critical component of the law to provide a check and balance on federal actions and their impacts on cultural resources. In Utah, we are committed to working collaboratively to keep the process moving and to never allow a we can't mindset to determine our course of action. Perhaps our greatest strength is that we recognize that the Section 106 process was meant to be pragmatic and solution-focused, not a means of stopping projects. Thank you.
Thank you. Dr. Merritt, Mr. McDonald.
Chairman Lee, Ranking Member Heinrich, and members of the committee, thank you for the opportunity to testify today on the need to improve predictability and certainty in the Section 106 review process under the National Historic Preservation Act. My name is Andy McDonald, and I serve as the Environmental Compliance Manager responsible for supporting Montana-Dakota utility companies' electric operations. Montana-Dakota is a small investor-owned utility company that generates, transmits, and distributes electricity to more than 145,000 customers across 185 communities in adjacent rural areas in North Dakota, South Dakota, Montana, and Wyoming. Section 106 of the NHPA requires federal agencies to define and document the area of potential effects of a proposed project. In other words, the area that must be assessed for impacts to historic resources. The implementing regulations define key terms broadly, and over time, these terms have been interpreted inconsistently and sometimes expansively, creating confusion and unnecessary delays. Montana-Dakota has experienced this issue on recent projects. In the example I'd like to discuss today, Montana-Dakota is rebuilding a 3-mile electric distribution line where approximately half of the line crosses federal lands managed by 2 different federal agencies. The project involves undergrounding lines for wildfire risk mitigation and upgrading aging infrastructure. One agency required the APE to include only the portion of land managed by that agency. However, the other agency required the APE to include the entire 3 miles, including portions on private land where no federal approval is required. It's important to note that there is an area of cultural significance on federal land in this area that we are working with the agency to find a path around that does not negatively affect those important resources. We're cognizant of the fact that these resources could extend onto neighboring private lands. Unfortunately, there is a perception among some that if the federal agencies don't have oversight over projects, that industry disregards any and all aspects of environmental concern. My experience over the last 10 years paints a brighter picture about our efforts to provide a reliable energy source to our customers while respecting the environmental and cultural resources that exist across our landscape. There are plenty of examples across the country of voluntary efforts made by industry to preserve our landscape and resources. In a situation such as the one I've described, utilities still have the ability to use consultants and work with the appropriate state and tribal agencies and private landowners to navigate a path around these areas without negatively impacting historic resources. This approach provides more certainty for industry and our federal counterparts. They know which areas they are responsible for, and we know which areas we are responsible for. This allows projects to be planned and executed in a more timely and economical manner. It will also allow federal employees more time to focus on other management needs within their respective areas. To be clear, our issue is not with the intent of Section 106 or the federal employees' efforts to interpret and implement it, but rather the absence of clear, predictable boundaries about what constitutes the relevant APE and what effects must be considered. As my example illuminates, this lack of clarity leads to inconsistent interpretations among agencies, regions, individual staff, consultants, and even utility companies. In certain areas, environmental conditions and wildlife restrictions leave extremely limited annual windows for construction to be completed, sometimes as little as 2 months during the year. In order to efficiently plan for rebuilding our existing infrastructure to more modern designs, as well as building new infrastructure to serve the rapidly expanding load growth, clarity is needed in the NHPA. Congress has an opportunity to enhance predictability and certainty to the Section 106 review process for all parties involved. Specifically for linear projects, clarifying that agencies shall review the geographic area or areas within which an undertaking may directly cause alterations in the character or use of historic properties, if any such properties exist in that area, and that agencies may only consider effects that share a reasonably close causal relationship to and are approximately caused by the undertaking. Lastly, clarifying that where the geographic area or areas of an undertaking includes multiple agency jurisdictions, agencies must work together to apply consistent standards with regard to reviewing potential alterations in the character or use of the historic properties. This preserves the spirit of the NHPA while restoring predictability and adding certainty to the Section 106 process. On behalf of Montana-Dakota Utilities Company and EEI, I appreciate the committee's attention to this critical issue and support Congress making changes to the NHPA to achieve a more efficient, consistent, predictable, and effective Section 106 process. Thank you for the opportunity to testify, and I look forward to answering any questions you may have.
Thanks, Mr. McDonald. Mr. Concho, we'll hear from you next.
Chairman Lee, Ranking Member Heinrich, and members of the committee, thank you for the opportunity to testify today about the Section 106 process under the National Historic Preservation Act. My name is Stephen Concho, and I am a member of the Pueblo of Acoma, and I serve as the Tribal Historic Preservation Officer for the Pueblo. I also sit on the Board of Directors for the National Association of Tribal Historic Preservation Officers, representing the Four Corners region. Our Mesa Top home at Acoma, also known as Sky City, has been where Acoma people have lived for more than 1,000 years. Our culture, language, and way of life are tied to an ancestral landscape that extends far beyond our present-day boundaries. Protecting these places is essential, not only for our identity, but for our survival as Acoma people. The Section 106 process is one of a few laws that requires the United States to listen to tribes before federal actions disturb places of historic, cultural, and often spiritual importance. Consultation under Section 106 is not a courtesy. It is a legal duty that reflects the government-to-government relationship between federally recognized tribes and the United States and their trust responsibility. Section 106 requires agencies to take tribal input into account by consulting at every stage, but it does not dictate an outcome or prevent development. Development may still proceed when a historic property is determined eligible for the National Register of Historic Places, including as a traditional cultural property. The National Historic Preservation Act simply requires that the federal agency consider the adverse effects a proposed development would have on a historic property before approving the permit. The preference is to avoid the adverse effects, and if that is not at all possible, the law requires mitigation. Consultation provides the tribes like ours with a seat at the table and a say in what the effects would be and how to avoid or mitigate them. It does not hand tribes a veto. When tribes are consulted early and properly, in my experience, almost all projects have moved forward efficiently and collaboratively in a way that that protects cultural resources. That's why early and meaningful consultation matters. On the other hand, when the agencies engage tribes only after decisions have been made, projects can stall because of fights over grant resources, resulting in rising costs. When tribes are brought in from the start, projects move faster and cultural resources are preserved. At Acoma, we saw firsthand the positive effects of early and meaningful consultation with a proposed CO2 pipeline that was going to cross 14 miles of Acoma lands. We developed a process to address this project that we call the Acoma model. From the very beginning of this pipeline project, the Bureau of Land Management, the energy company, worked directly with the Pueblo of Acoma. The Pueblo entered into a cost reimbursement agreement with the company, so our cultural experts could work alongside the project archaeologists and engineers. Together, in 6 weeks, working with a team of knowledgeable Acoma cultural practitioners, the project team surveyed 14 miles of Acoma trust land, identified more than 150 cultural sites, including 90 that would have never been recognized through standard archaeological methods, and successfully rerouted the pipeline corridor to avoid them entirely. That collaboration saved time, avoided conflict, and protected cultural resources that are important to the Acoma people. This is what successful consultation looks like. Our office manages dozens of consultation requests across 4 states every month, with minimal staff and limited short-term federal funding. Like many tribal historic preservation offices, Acoma operates roughly on $100,000 a year, barely enough to cover salaries, travel, and essential operations. This level of funding forces all TIPOs, including ours, to triage projects and stretch limited capacity, which can lead agencies to misinterpret slower response as delays. In reality, the fastest and most effective way to improve consultations for everyone, tribes, agencies, industry, is to invest directly in TIPO capacity. Mr. Chairman, members of the committee, the Pueblo of Acoma urges Congress to reaffirm support of Section 106, strengthen support for tribal historic preservation offices, and ensure that early, well-funded consultation remains a cornerstone of responsible federal decision-making. Thank you for your time. I look forward to your questions.
Thank you so much. We'll now begin 5-minute rounds of questions, alternating between Republicans and Democrats in order of seniority, subject to the early bird rule, and we'll begin that now. We'll start with you, Dr. Merritt. Now, the statutory text that we're dealing with here, Section 106 of NHPA, is ambiguous. It provides simple, broad directions suggesting that federal agencies need to consider effects on historic properties. Now, while there are regulations that spell out some of the details and something of a process, they also leave significant details open to interpretation. As a result, the scope of what can be considered during the consultation process has ballooned rather dramatically. How do you determine the appropriate area of potential effects as you're reviewing them? And how do you keep that area proportionate and relevant to the direct impacts on the project?
Thank you, Chairman, for that question, and I'll nerd out for a second for everybody's sake. So the area of potential effect in 36 CFR 800 is defined by the direct effects, so think about digging, trenching, et cetera, physical impacts. But there are portions of the APE that are dealt with visual, atmospheric, and auditory. It is those parts, those indirect effects, that do draw the APE larger in many cases. I will say of the 1,500 cases that we review a year in Utah, only a few dozen, if not 1% of those cases, have what we would call a variable APE based on those resources. And so, as you point out, it is ambiguous, it is vague. And there's positives for that, and there's also very negatives, as Mr. McDonald has mentioned. And so we work through a consultation process. And so the agency approaches us on a proposed area of potential effects at the SHPO or the TIPO, and then other parties also have an opinion on what that APE could look like. There is need, in my opinion, to better define some of these aspects, to create reliability in establishing APEs and other effects. The other thing I want to say is I have a three-stool approach in Utah: practice, data, and relationships. Practice, to me, is an investment up front of setting up reliable standards. And so for a long time, Section 106 is a very reactive process. I would like to be proactive and come up with established rules as projects come forward. There is a rule book for these proponents and other parties to play by versus having every single process through the sausage grinder end up in a different place.
Yeah, no, and that makes a lot of sense. Now, under the current process, what determines the extent of indirect impacts when you see them, and how can those indirect impacts be objectively and reasonably quantified when determining the adverse effects? Is that part of the difficulty here, is figuring out how to quantify, how to evaluate relative indirect impacts?
Yeah, that's a great question. So when we talk about effects, I will go to the parallel law, the National Register of Historic Places. When we designate something eligible for the National Register, we're supposed to say, what are those character-defining features that make that site significant? When we go into the 106 process, that's how we assess the impact of the project. Are we changing those factors that make it eligible for the National Register, those character-defining features? And I have to say, I cannot quantify, and I cannot come up with an objective measure of indirect effects because it is so variable based on the resource itself. A small uranium mine in central Utah is going to be a different assessment than perhaps a tribally important landscape in another part of our state. And so that's why it becomes very tricky when you're assessing those visual and atmospheric and auditory effects to come up with a regular agreed upon pattern. And that's why, again, I go back, like I'd like to invest early and set up standards so not every single project has a different outcome.
Right. It would diminish the subjectivity inherent in it, and when you have less subjectivity, you're probably going to have a faster, more straightforward process.
Absolutely, sir. And I think the subjectivity creates frustration from agencies, tribal members, nations, and proponents. I think ambiguity is sometimes the big problem.
Yep. Now, Mr. McDonald, in your testimony, you state that the quote, the NHPA Section 106 implementing regulations define key terms broadly, and over time, these terms have been interpreted inconsistently and sometimes expansively. This is a fundamental issue, isn't it? One with many, one that we face with many permitting statutes, including this one, including NEPA, wherein there's a fairly simple procedural requirement in a statute that's been weaponized, or it's at least wandered beyond its original scope, the scope of its original understanding. To what extent has this particular lack of clarity in Section 106 delayed MDU's distribution line?
Senator, thank you for the question. In this particular project, it's delayed it on the terms of months more than years, probably about 12 to 18 months in the process. This also is a line where we're dealing with kind of going up the side of a mountain to a certain extent. So our timeline for construction for this one is about a 2-month window from when the snowpack comes off to when we're getting into the portion where it's too dry to work on. So it's not necessarily the consultation process that resulted in that length of delay, but because of the timing of those decisions and how that process has kind of been held up because of the kind of the misunderstanding of where we need to look at and where we don't need to look at for projects, or where we need to work with state or tribal partners versus the federal partners in that process. We've missed that window, and now we're waiting another construction season to address that line.
Thank you. Senator Heinrich.
Thank you, Chairman. For Mr. Concho to begin with, and then I want to hear Dr. Merritt's opinion as well. In your experience, what would expedite consultation with states and tribes, and how much of this is ambiguity and how much of it is fundamental resourcing the offices that evaluate these projects? Mr. Concho.
Yes, thank you for your question there. I think, as I stated, that what works for Acoma is the Acoma model, which does force the project proponents to consult with the tribe and bring us in at an early stage. That way, we know exactly what's going on and how we can approach the projects together. And it has worked, and we have had very much success with that model. And so I think just involving the tribes and getting them, bringing us in early, at an early stage, really expedites and often in the long run saves costs.
Right. Dr. Merritt.
So I feel I'm very lucky to work in Utah because our governor and our legislature provide us the tools to do this efficiently. So always the knee-jerk answer is like more money, more staff. And in some cases, in some states and many tribes, that is very, very true. In Utah, that is not the case.
What's your overall budget in Utah?
So this is a good question. So we receive 60% of our budget from the National Park Service through the Historic Preservation Fund. So I'm sitting up here 60% federally funded. And so that's just a tad
What's the stateside piece?
So the state side is that 40% match. So it's about $1 million from the feds and then, $700,000 to $800,000 from the state. And so your question towards efficiencies, I think, again, it goes towards early and often. I think you're going to hear that a lot, is a lot of the projects we see in Utah that go sideways, if we had had better integration very early on in the process, if the proponent had been told, like, this is an expectation, if the agencies talk to each other, I think all of those embed efficiencies in the system.
Say that last part one more time, because that's been my experience as to many of these big infrastructure projects. One of the fundamental challenges is when the agencies
don't integrate themselves and they don't
talk to each other early in the process. Absolutely. Mr. Concho, what's your budget again? Did you say $100,000?
Yes, a little over $100,000 is the appropriations that we receive.
And do you receive any federal funds as part of that?
We don't have. It's mostly just grants and then some if there is some tribal funding to supplement.
Okay, Dr. Merritt, I want to ask you if there are tools that we should be using that are underused widely in this process. And I'm thinking, because people made the analogy to NEPA. In NEPA, we have categorical exclusions, and those apply to things that are where the fact pattern is demonstrably the same over and over and over again. And so you analyze those as a basket rather than every single individual time. Are there tools like that within the National Historic Preservation Act that you think we should be utilizing more?
Thank you, Senator, for that one, because this is one I'm really passionate. My 13 years at the state, I have invested heavily in what we call programmatic agreements. So in the 800 regulations that implement Section 106, they give us the tool to create agreements that can make routine or even complex undertakings into an agreement document that you enter the sausage grinder and you know what you're going to end up with. Programmatic agreements have the ability to do what we call streamline, and that is putting those things in buckets or baskets or whatever analogy we'd like. And that allows us efficiencies in the system because not every single fence restringing project or every single USDA disbursement to a farmer for a crop replacement, that doesn't need to go through a full four-step process. And so we can use a programmatic agreement to say, analyze it at the agency level, do your tribal consultation, but we don't need to see the project at the state SHPO. You send that to us at the end of the year. And so that's where our caseload is probably higher than 1,500 because we put so many of those cases into large buckets.
Those buckets, yeah. Mr. Concho, given the history of our country, the history of your Pueblo, why is it important for us to hear your perspective when we consider historic preservation issues?
Thank you for that question. Yes, it's very important that you hear the Pueblo's perspective because from where I where I'm from, we have lived this life for almost 1,000 years. And I'm here as a TIPO in this capacity, basically because I love what I do, I love my job, and I do this for those folks yet to be born, to protect the area where I'm from. It's because it's been we have footsteps all over the Southwest, and we still continue to migrate and visit and touch these places like Mesa Verde, Chalco Canyon, and protect these places through song, through prayers. And also, often we go and visit these places still today. These places, people refer to them as ruins or abandoned, but they're not. We still go to these places. They're living places that still hold meaning to the Pueblo people. And this is kind of what where I come from the Southwest, from the Pueblo of Acoma, one of the oldest continuously inhabited cities in the United States. And we're happy to be that way because we still continue to have our traditions as they were given to us for 1,000 years. And protecting all these places in between keeps our tradition alive, keeps our tradition growing.
It's a living cultural landscape.
Yes, sir. It's living culture.
Senator Justice.
Plain-spoken guy from the state of West Virginia, very proud of it, done a lot of stuff. And I would just say just this. We absolutely should always continue to ask ourselves, and I wrote it down, is can we protect and move forward at the same time? It's just that simple. And the next thing that I would say is just what my dad has said many times, but I'll never forget this. You know, my dad was a graduate as an aeronautical engineer from Purdue University, and right after he came out of that, he enlisted in the Air Force, and lo and behold, they taught him how to fly, and he was flying a B-29 bomber, World War II. Now, you just think about that guy and how great all those folks were, men and women, at that time, and the contribution that they made to all of us, to each and every one of us. That guy stood at an engineering table with 2 or 3 engineers and the superintendent of a job, and they were trying to figure out exactly where to put the road. And I'll never forget this till I die. They went on for probably an hour and a half, and then at that time, Dad said to the superintendent, said, "Kirby, I don't know exactly what the right answer is, but this damn well ain't it." Now, that's all there is to this whole situation here. We know what all the red tape and all the problems are, for crying out loud. We know that we want to protect. You spoke, sir, about the ruins and everything that people are calling, but they speak to you, do they not? They do. We know we have to protect. We know that. But at the same time, we've got to find a way to move forward, because really and truly, the red tape, the permitting process to do anything. You know, see, I'm a business guy. The permitting process is so absolutely bogged down, it's unbelievable. And you talk about sausage, I mean, for crying out loud, it is the most bizarre things at times that anybody could ever imagine. So we got to do something about it. And we got to fix it. And we're smart. And we have the ability to fix it. Please, let's quit denying. Please, some way, somehow, let's quit denying that we don't have that we have a problem or we don't have a problem. I mean, it is preposterous to think just how bad the problem really is. You know, we got to live here too. That's all there is to it. And we got to do things. And we got to try to make things better. And we have an energy meltdown right on our doorstep. And we got to do something about that too. If we don't watch out, we're going to spin around 2 or 3 times. And this great, great, great nation, we're going to say, uh-oh, we got a real old Duke moment. And so with all that being said, I've really only got just one question. And this would be to Mr. McDonald. And it's so obvious it's off the chart, but, you know, what we've written here is, can you provide an estimate of the direct cost, personnel, survey work, legal expenses, on and on and on, that are solely attributable to Section 106? A process for a multi-state project and how that cost is ultimately passed down to the American energy consumers. To put it plainly, can you give me an estimate of how much American taxpayers are paying for the federal government's complicated process? Please, sir.
Thank you for the question, Senator. So our utility isn't quite the largest utility. We're in fact pretty small in the grand scheme of things. We can certainly visit with some of our counterparts, and I can get you a more reasonable estimate for that answer for the record, if that's acceptable.
Well, surely it's acceptable, but the bottom line to the whole thing of what I'm trying to say is the whole process here is not working. The process is ungodly expensive, and it is absolutely a time consumer like nobody's business. You just got to do something about it. Mr. Chairman, thank you, sir.
Thank you very much. Senator Cortez Masto.
Thank you, Mr. Chairman, the ranking member. Can I just ask all the panel members, do any of you agree that we should eliminate entirely the Section 106? Anybody that agrees with that?
No.
Mr. McDonald?
No.
Mr. Merritt? Mr. Concho? Thank you. I think there's opportunity to streamline, and it makes sense, and I appreciate all of you coming here, but obviously this is necessary, and it does work in some faction, and what we are trying to figure out is where we can streamline it. And all of you here are important in helping us make that determination. Mr. Merritt, thank you for being here and the work that you are doing for the state of Utah. As a neighbor in Nevada, we appreciate that. Spent a lot of time in Utah. Let me ask you this. You talked about APE should be further defined, atmospheric, visual, auditory. How would we define that at a federal level without implicating what you said, the uniqueness of each project in every other state?
Thank you, Senator, for that. And I've enjoyed working with the Nevada SHPO for many years, so it's good to see you today. That's tricky. I've asked myself that, is like, where in the regulations can we make this more clear? Because I do feel there are points of it. I don't know how to do it at a broad level. This is why Utah is different than Nevada, is different than Wyoming, is different than Maine. And that's why, again, I go back to that federalist approach, is the problems that I've sometimes seen with national agreements from the Advisory Council, other places, is it's a one-size-fits. And I am not Indiana. I can see things on the landscape for very long distances out here in the West. And so it's very hard to put a pinpoint at a regulatory level. I think there are ways, and we can be creative looking at the language of how the 800 regulations are written to better define and limit by landscape, by landform or something, because there are points in the state where we've had a 10-mile buffer for a power line, right, irregardless of if there's a mountain between it and that 10-mile buffer. So there's smarter ways we can do it. But I always come back to the federalist approach is I want to have a seat at that table helping define that for the best for the people of Utah.
Yeah, and I agree, and I think it is so important we have local stakeholders there. I think that was the intent, right, is to have the local stakeholders involved because you know the land, you know better what is going on and the challenges that we are facing to address the concerns that we're looking at. Can I also ask one final thing? You get federal funding from the federal government, but Mr. Concho, the tribes don't get federal funding dedicated. You have to fight for it through grant funding. Is that correct?
It's for the TIPO, if you're a TIPO department, we do have to submit our grants yearly.
But you don't get directed federal funding like a state office would? No,
we have to go through the National Park Service funding for TIPO.
So it is. Is it the same process?
It's also a grant for us as well. It's the Historic Preservation Fund provides the funding for both SHPOs and TIPOs.
And it's a grant process that you all apply for.
Can I answer?
Yes, please.
So the appropriation that comes from the Historic Preservation Fund comes from offshore oil leasing royalties. And so it's not really taxpayer money in that sense. The problem that we have is that there's 59 SHPOs. There are over 200 TIPOs, but the pie doesn't necessarily grow, right? So we're not adding states every single day,
Okay.
but we are adding TIPOs. And so the pie for a TIPO is smaller every time there's a new TIPO created, versus my pie has expanded a little bit because of population dynamics and other features that the National Park Service uses to apportion our grant. But we are both applying for grants to support our office.
So would you recommend that's another area for us to look at, is how we provide equitable funding? Because it seems to me the SHPOs and TIPOs are key to this process. This, if we're looking at ensuring that you're there at the table helping to make these decisions, or should we not look at that formula?
I would say, from the questions I'm hearing today, everyone wants to find solutions. And so I think every step of these questions, there's solutions to be found. Maybe it's funding, maybe it's procedural, maybe it's regulatory. But I think all of it needs to be looked at, because not every state is lucky as we are in Utah to do as good as we can, because we have the support.
And you have the dedicated staff, and I appreciate that. Let me ask you one final question. I'm running out of time. Department of Interior is planning on laying off 2,000 individuals. How important is it, the Department of Interior, to have staff that are funding and working on this 106 process?
So to answer that question is, overwhelmingly SHPOs feel that with employee turnover at the federal government, lack of staffing at the federal government, it puts more pressure on us to do the work. And more pressure, I won't speak for the tribes, but I've heard from tribes that they feel more pressure. As those positions dry up or people are retiring, it does put more weight on us to carry the load for these federal agencies. And I cannot imagine a world where the lack of federal employees is not going to hurt permitting and not hurt review processes.
Thank you. Thank you again, all three of you.
Senator Cotton.
The consulting firm McKinsey estimates that the average proposed project subject to environmental review takes 4 to 5 years to move through the permitting process, with an average of 4 additional years spent litigating the project. According to the Breakthrough Institute, 75% of environmental litigation, like NHPA, is driven by a handful of environmental NGOs. Of the challenges, 10 organizations are responsible for more than 1/3 of often frivolous lawsuits. Agencies win approximately 80% of these cases. Nevertheless, litigation by these NGOs demonstrably slows and even kills necessary projects that could have lowered cost for consumers and increased reliability. Mr. McDonald, radical environmentalists have abused our court system and weaponized statutes such as the National Historic Preservation Act, the National Environmental Policy Act, and the Clean Water Act to slow or kill needful projects to increase supply and lower costs. Given this legal landscape, what reforms, in your opinion, are needed to stop this kind of radical lawfare and lower electricity prices for consumers?
Senator, thanks for the question. As was described in the testimony, I really think that the certainty that's provided with the regulations that we're asking for here will eliminate some of that. I'm not naive to think it's going to eliminate all of that, but I certainly think that, you know, if we have clear direction on what our responsibility is in the statute, it provides for less uncertainty and less kind of ambiguity in what our responsibilities are in those issues.
And if one of these radical groups unsuccessfully sues on a project, are they barred from suing under other statutes, or are they free to proceed under other statutes?
Senator, I'm not aware of the answer to that question, but perhaps somebody else with a better legal background would understand that.
I think they have many other statutes that they can proceed under, so they get multiple bites at the apple. When a project is shuttered because of such lawsuits, are construction workers and operators still paid?
Thanks for the question again, Senator. I would have to get back to you on that one as well. I'm not aware of the answer to that question.
Well, given that most workers are being paid by the hour, I think it's probably fair to guess that they're not being paid, which means this kind of lawfare is not just causing electricity supply to go down and prices to go up, but hardworking construction workers not to be paid. How does the threat of such open-ended lawsuits affect your decision-making for projects at MDU?
I think with all projects, and lawsuits or not, we always strive to do the best job possible. We work with our state, local, federal partners, tribal partners in instances where we're working on tribal land. We always try and do the right thing. And again, the clearer the statute is, the easier it is for us to plan for these projects, to execute these projects in an efficient and predictable manner.
Okay. Thank you. I yield back my time.
Senator Gallego.
Thank you, Chairman Lee and Ranking Member Heinrich, and thank you to our witnesses for your attendance today. Like many of the states represented on this committee, my home state of Arizona has widespread historic resources to teach about our past, honorable tribal heritage, and drive tourism to our state, a lot of tourism. We're also experiencing tremendous population and energy demand growth, meaning we have to find ways to both grow quickly and responsibly. I've been a vocal supporter of building out housing, energy, and transmission resources as fast as possible, but also been vocal that we can't do so in a way that hurts and cuts our community and tribal input. For example, Arizona State Historic, our SHPO office, has reviewed more than 3,000 federal projects into consultation in the past 3 years. Their average turnaround time is less than 30 days, and their adverse effect rate is below 2%. This means they're following the law while keeping things moving and even improving economic investment and community relationships. I believe there are ways to streamline, though, and improve Section 106 review without bypassing community input, and I look forward to hearing your thoughts on all of this. My first question is for Dr. Merritt. Last week, Arizona's SHPO officer sent a letter to the superintendent of the Grand Canyon highlighting ways that they can work together to streamline construction of a new Grand Canyon Lodge after it was destroyed in the Dragon Bravo fire this summer. Reconstruction of the lodge will require significant build-out of energy and water infrastructure, as well as the building itself. The letter highlights ways that Section 106 can be streamlined under existing authorities, including synchronous reviews, exemptions of certain activities from 106 review, and real-time, on-the-ground decision-making. Do you think that most states currently use streamlining authorities like those outlined by the Arizona SHPO officer to the greatest extent? And is there room for improvement under existing authorities?
Thank you for that question, Senator, and that was sad to lose that facility.
I know, trust me, it's a tearjerker for all of us.
I think it's always variable. And I do think most SHPOs employ programmatic agreements to find ways of streamlining and efficiency. This comes back to my third leg of the stool, the relationship building. Is programmatic agreements are only as good as the relationship we've forged between the SHPO and a federal agency. And I'm very happy that the Arizona SHPO has that relationship with the National Park Service to agree to allow things to move streamlined in a way that's structured. I'm also applauding the Arizona SHPO to be proactive, working with the Park Service to plan for this versus waiting. The long answer is yes. I think many SHPOs use these agreements, but I think we can expand their utility. And instead of perhaps what I'm advocating is instead of having project-specific agreements to be more programmatic in sense of projects by the Park Service in Arizona as a whole, or other agencies, because I think those we find a lot of embedded efficiencies that can help.
Gotcha. My next question is Mr. Concho. Many Arizona stakeholders have highlighted that tribal consultation under the Historic Preservation Act is not only required under federal trust responsibility, but extremely valuable for wildfire rehabilitation, trail construction, and much more. Can you speak more about the value of tribal historic preservation officers? What would be lost if the opportunity for tribal consultation is narrowed or reduced?
Oh, yeah, thank you for that question. Tribal historic preservation officers are very important to the communities and the states that we live in, especially in the Southwest state where there's high concentration of sites in the areas there. Without tribal historic preservation officers, that all could be lost or not protected further from telling us our history. As I mentioned earlier, our history stems for a long time, and we're here to protect that history. One thing to keep in mind when talking about SHPOs and TIPOs is that being a tribal historic preservation officer, we did take on those responsibilities from the SHPO and brought them home to, like for my example, to Acoma. And there is where I, see these projects come through my office. And at the same token, you have thousands of requests that come in through my office yearly, and with a staff of only maybe one or two. And so you can see how that amounts up and how we have to prioritize what we have to do.
Slows down things too.
So I think additional funding to help us maybe hire additional staff would help streamline those decisions that we have to make as tribal historic preservation officers to protect our cultural identity.
Great. Back to Dr. Merritt. In FY24, Arizona's, and I kind of said in my comments here, Arizona SHPO Office reviewed 1,451 federal and state projects with an average turnaround time of just 20 days, flagging only 2% for adverse impacts requiring mitigation. That's pretty efficient, in my opinion. It's my understanding the National Park Service used to collect performance metrics like this for all states, but no longer does. How can we know how much Section 106 is holding up projects if we aren't collecting and sharing that data around it? Besides anecdotal.
Yeah, thank you, Senator, for that. And I do think that there's the reporting mechanisms for us to receive our grant. I think that's another place for accountability for our offices and what we're doing. I have relationships with the governor and the legislature to report those statistics as well of how efficiency. And I've already told many folks here, like, if a complaint of a 106 project makes it to a legislator or to a Congress, I've screwed up. Because that's how sometimes the measurement of success of Section 106 is measured, is how many people are complaining about it. And so I don't want that. I want to work to make this function and smooth, and I don't want people finding problems with it, because that's the true accountability, is the more people that are finding errors with it, the more I'm not doing my job.
Thank you. I yield back.
Senator Murkowski.
Thank you, Mr. Chairman. Mr. Chairman, Ranking Member, thank you for the hearing. As we're focusing on permitting reform more broadly, I think it's very important that we are doing a more focused review of Section 106 compliance and how this all works. Thank you for being here before the committee today. My colleagues know that I often start my comments by saying Alaska's unique. Our situation is just a little bit different. And I think in this situation, again, that just underscores we're big, we're a young state. We've got a lot of properties that may have impact to traditional religious or cultural significance given the fact that we have 40% of the tribes in the country. We want to make sure, we must make sure that the consultation process is coordinated, it is efficient, but honors that government-to-government consultation, and that tribal voices are meaningfully heard, not just this is what's going on and we'll check in with you later, but being there at the beginning. We also recognize in my state, again, I mentioned we're big, we've got about 80% of the state that has never been surveyed for historic or cultural properties, and so this presents its own set of problems when you have even very small or low impact projects that may then trigger Section 106 reviews across huge areas. So I'm going to put this out to Dr. Merritt, but gentlemen, any of you can reply to this. Just a couple concrete examples of how this is playing out. In Southeast Alaska, we had our telephone company, power and telephone company. They're trying to bring broadband to a very small community, Dyea, and the National Park Service required 500 hand-dug test pits along a 1.7-mile route. So this was going to be more ground disturbance than laying the fiber itself. The project was delayed, and the community basically lost out on that. And so it's an example of project risk that is very small, but you have essential infrastructure that is effectively being halted. And we want to do all we can to protect historic sites. We understand that, but again, just looking at the scope of this, another project is in Northwest Alaska. Two mineral exploration projects, Anorak and Atigaruk. 30 months of review, 7 EA extensions, conflicting findings between the Corps, SHPO, and the IRA Council, ultimately halts the construction despite extensive consultation there. So the question to you all is, when you have, again, projects that are very small, project risk so small, these repeated reevaluations that effectively do nothing but delay projects. And again, I'm coming from a state where our construction seasons are limited. It's truly a season. It's not 365 days. You might have 4 months at best to advance your project. So, Dr. Merritt, let's just start with you here.
Thank you for that question, Senator. And I can't see the ground in Utah, or I can't see the ground in Alaska, but I can see the ground very well in Utah. And so that's why there's different methods that each state employs. And that goes back to state-by-state solution. But I think, again, it goes back to relationships and finding common sense solutions to get through these projects. Is sometimes doing shovel probes or shovel tests is what we call those makes sense. Other times it's become perfunctory. We always do them because we always have done them. I can't speak to the Alaska SHPO and why they move forward on that, but I can speak to the other issue of having multiple agencies not working well together. And I've seen that time and time again, not because that the solution is bad for anybody, but because the coordination stank at the very onset. Is the Army Corps maybe not coordinating with another agency early on, or the other agency not knowing there would be another agency's involvement, and so we get multiple steps, multiple horses in the race that don't even know they're racing each other. I've seen that happen multiple times in the implementation of this law, because we do have ourselves tied to NEPA. We have to complete the 106 process before a NEPA decision can be reached. But sometimes I've worked for the federal government. I've worked for the Forest Service. And I remember examples of working under NEPA and the NEPA shop not telling the archaeologists of what's coming. And so we're now the bottleneck, because most NEPA is desktop, looking at stuff from computers and books, versus most archaeology is on the ground type of work. So I've seen delays from that way in communication, and also just every single time thinking, are we doing this the smartest for the people that this project is trying to serve? I never separate myself from the point of the project. I don't care about what the project is from a regulatory standpoint. My job is to just make it move as quickly as possible.
Well, it sounds like you're not satisfied that we have a process that is efficient and does allow for a, whether it's a multi-track, but just recognizing that understanding what this process may look like, timelines that are realistic, could help us with our efficiency.
100%. When a proponent calls me, because they know they have to enter into a consultation with the BLM to get a permit, I try to walk them through as clearly as I can, like, expect this, expect this. When you meet with the BLM, let me know. We can communicate with the BLM to move the project along. And so it's communication, and sometimes we stink at it.
Thank you for that. Thank you, Mr. Chairman.
Thank you, Senator Murkowski. Senator Hickenlooper, you're up next.
Thank you, Mr. Chair, and thank all of you for being here. Thanks for your work. Expanding and updating our electrical grid is critical, I think, to ensure reliable, affordable, dependable electricity. Many of us up here have sponsored a number of bills in that direction. In Colorado, we've seen how valuable it is when energy developers and agencies consider cultural and historical context and the resources up front in the processes of much-needed grid expansion. I think you've all touched on this. Let me start with Mr. Merritt and Mr. Concho. What are your ideas for how we can minimize the impacts to historic and cultural resources while at the same time being more efficient or speeding up the build-out of critical infrastructure like transmission, which the country depends upon? Mr. Concho, why don't you start?
Thank you for the question. I believe, like you mentioned, first and foremost, the bringing on the tribes that belong to the areas that are being affected with the project proponent, bringing them together at the table as the project is being, at its inception, is the most important part in this whole thing, because you get the input from tribal representatives, plus that's tribal knowledge the elders, the people that live there, that have lived there, know where certain things are at, know where certain historic and sacred sites are at. And so coming from the Native American perspective and coming from the Southwest, it's very important, and especially in the Southwest, because you can't walk at least maybe a mile and not run into a place of cultural significance. And that's how important it is for the TIPOs, and just to come to the table early and involve the tribes at an early point.
Great.
I struggle with being pithy, but I will try to do my best because this is a very interesting question. So in Utah, we have spent most of this year working on a draft agreement to look at geothermal. We're getting an increase of geothermal projects in Utah, and I want to be ahead of it. I want to be ahead of the gold rush for this new energy source that could redefine our nation's dependence on other energy sources. But we're investing up front. Like, let's set up a firm process for any geothermal company anywhere in our state. What are the expectations? Where can you find and move quickly? Where do you need to slow down? So I think that's one big piece, is being proactive ahead of the game. We've established similars for solar on the western side of Utah to make solar projects simple when they come in, simple in a grand scheme. The second thing is you brought up historic context. So nerd out again for you. For everybody's sake, the National Register of Historic Places urges people to create historic context. So it's a playbook. So you're out inventorying, you find a type of building or an archaeological site, you go through this already pulled together resource to determine what makes that resource important or not important in the eyes of the law. I'm a big proponent of these because it does help standardize when people are going to the field. I find A, I look at the document, I conclude B, versus every single resource kind of winging it. And so I think that does offer another place of structure. And so we invested in Utah with partnership with the Bureau of Land Management, historic context in our oil field in northeastern Utah, looking at very commonly discovered sites, sheep herder camps, Native American open campsites. And so we just wanted to invest a lot early on.
Right. Well, I appreciate that, and I think that's crucially important, making sure that we reach out. A little part of my, or a relatively unknown part of my past is my business would renovate old historic buildings. I spent a lot of time working with historic preservation in local communities around the western United States. 1997, I was proud the National Trust for Historic Preservation gave me their Award of Honor. Much ado about nothing, as my wife said. But I do think, Mr. Merritt, I think it is incredibly valuable that we take into consideration exactly what you're working on and making sure that we are out front. The Trump administration had removed 3 members of the Advisory Council on Historic Preservation earlier this year, and then 2 more resigned. This is in addition to the staffing cuts we've seen, not just for the council staff, but for federal land management agencies, other agencies leading projects through the entire Section 106 process. Can you speak to the impact that these vacancies and staffing cuts has made, especially on energy projects?
So in Utah, we haven't seen as many of the federal layoffs as in other states. The vacancies at the Advisory Council of Historic Preservation could hurt us in the long run of putting forward program comments that could help expedite nationally some of these agreements. But increased vacancies at federal agencies in Utah will slow the federal government's response to permitting applications and reviews. And so while we're not seeing it yet in Utah, I know other places are. And so it is a concern of ours because the more that the federal agencies don't do their job because of staffing, the more it falls to us.
Got it. I hear you loud and clear. Thanks to all 3 of you. I yield back to the chair.
Thank you. Senator McCormick.
Thank you, Mr. Chairman, Ranking Member, and thank you to our 3 distinguished guests. I'm grateful this panel of witnesses is come here to discuss an important issue for our permitting process and jobs pipeline in Pennsylvania. The reality is that regulatory inconsistency and duplication across federal agencies are unnecessarily delaying and hindering vital infrastructure projects across the country, including in my state, the Commonwealth of Pennsylvania. And that's why I'm committed to streamlining the permitting process and examining the different regulations and rules put in place, such as the Section 106 consultation process under the National Historic Preservation Act. The NHPA process currently slows down our ability to build, update, and modernize due to several specific failures that directly impact our state's economy. This includes the fundamental regulatory inconsistency across how different federal agencies apply the rule, often resulting in duplicative and overly expansive consultations by agencies like the National Park Service. We also face challenges from the Bureau of Land Management's deference to tribes and their required changes on previously agreed upon plans, which creates crippling uncertainty for developers. Compounding all of this, the reliance on subjective and difficult to measure concepts, like the traditional cultural properties, TCPs, allows for decisions that go beyond clear statutory requirements, treating vague concepts with the same significance as clearly delineated historic sites. Now, for Pennsylvania to secure our future and lead in manufacturing, we need reforms that impose firm deadlines, clarify the scope of review to the project's actual disturbance, and exempt critical infrastructure like utility poles and transmission lines from being unnecessarily flagged as historic. So with that context, Mr. McDonald, last summer in Pennsylvania, we hosted the inaugural Pennsylvania Energy and Innovation Summit, which convened President Trump, his cabinet, and leading CEOs from energy, technology, and energy sectors. Throughout the day, participants raised our urgent need to build new energy infrastructure quickly and efficiently to meet the growing demands for energy. In your testimony, you discussed the unexpected delays MDU faced when rebuilding an electric distribution line due to Section 106 of the National Historic Preservation Act. Given that U.S. electricity demand is projected to increase by nearly 80% by 2050, how do you expect the current Section 106 process to significantly hinder critical energy development?
Thanks for the question, Senator. I think the answer is it varies, and that gets back to the point in my testimony about the clarity needed in the statute, depending on which federal agency you're talking to, even which consultant, which utility company. There's just been a lot of different interpretations of how do you define that area of potential effects and what the project is establishing there. So, I mean, potentially there are projects that'll go on as planned and everybody will agree upon the same interpretation, but without that clarity in the statute, it is still a bit of a guessing game on how these projects are going to run and how efficient they're going to be planned and executed. And as I spoke to with that example, again, we're dealing with about a two and a half month window for construction. So even a delay of a month or two, depending on the timing of when we get to that point in the process, can lead to a further delay depending on what your construction season delays are.
Advice on what changes policymakers should pursue to address critical infrastructure delays caused by Section 106?
Yeah, thanks, Senator. We can get you more like definitive language on what that looks like. I think it's really just for linear projects in particular, if we're not receiving federal funding, which we typically don't, we're an investor-owned company, it's pretty rare anyways, but if we're not receiving federal funding, then our thought is the jurisdiction for the federal agencies and the consultation projects is the land that they manage. That would be our suggestion, but we can follow up with more distinct language there too.
Very good. Mr. Concho, I have a question for you, but I'm not sure I'm going to have enough time, so I'll submit that for the record. Thank you.
Senator Padilla.
Thank you, Mr. Chairman. Colleagues, just want to echo what the sentiment that's been shared from several members already, and that's the importance, obviously, of truly meaningful tribal consultation. Consultation through Section 106 at the National Historic Preservation Act is a critical tool. Within California, we too have a State Historic Preservation Officer, a SHPO, and in 2024 alone, SHPO completed roughly 4,100 reviews under Section 106. So it's not a slow, sleepy office. It's a very busy one, in addition to being an important one. This has included individual project consultations for efforts such as road projects, solar installations, and hazardous fuels projects in our forests. California is home to 109 federally recognized tribes, more than any other state in the nation, and over 50 of them have THPOs, the Tribal Historic Preservation Officers. And we value this because tribes have traditional knowledge of the land and resources that have been significant to their people since time immemorial. That's why it's critical for the federal government to meaningfully engage with tribes when pursuing projects that could impact their cultural resources. And the key word I want to emphasize here is meaningful. Tribal consultation is not just a quick call, an email, whether or not it's replied to, simply for the purposes of checking a box. Meaningful means meaningful. Mr. Concho, I know in your testimony and some of the Q&A with other members, you've talked about not just the quality of engagement, how important that is, but the importance and value of early engagement as well. I think for the benefit of some of the members of the committee, can you give some examples of how early engagement can lead to either reduced costs down the road, less risk of a project getting to the finish line, if you will, and the long-term viability of some of these important projects?
Thank you for that question. Back at Acoma, like I referred to as the Acoma method or the Acoma way, we did meet with one of the Kinder Morgan projects that was coming through our area, and we did meet with them from the onset, and we partnered with them, and we met with them, and we brought in our tribal knowledgeable people that know the land and know my elders. And we, with the governor, along with the council, we sat and we talked about this project and how it's going to go and where is it going to go and how is it going to affect the land. So we worked with them. We worked with them to agree on a specific area that we're going to survey. That way, we have enough room to say, oh, there's a cultural property here, there's something significant here. That way, that pipeline, we can then say, okay, we're good with this project, let's move forward. And by doing so early, it allows the proponent to say, oh, well, we sat with them, this is where it's gonna go, the monitors are there with us, and so they got done with the project in 6 weeks. There are other projects ongoing currently, such as a fiber optic project that's going through the Pueblo that we're working alongside the proponent with that project. So we're not saying that this Section 106 stops or gives the tribes permission to halt the project, but as long as we're working together, we can see outcomes and look at these projects through and see that they don't affect any of our cultural resources.
Wonderful. It seems to be an elegant evolution of what is referred to sometimes as the carpenter's rule, right? Measure twice, cut once, right? If you're thoughtful on the front end, you're not having to go back and redesign and accommodate for things that you learn later in the process because you consider them much earlier. Dr. Merritt, quick follow-up question for you. What are some of the best practices that have allowed responsible development in Utah without undermining tribal resources?
Thank you, Senator, for that question. And so I'll just refer back to my talking points. It's focusing on the process, the data, and the relationships. Is in Utah, like our Department of Transportation has actually set up consultation agreements with tribes. So the tribes aren't being inundated with projects that they're not typically concerned about as a way to limit down the workload for our tribal partners. We also focus on the digital workflows, and we provide data sharing to all our state and federal partners to provide that information in real time. And all of these efficiencies allow us, much like Mr. Concho is saying, to invest up front to make the best decision. Is the better data we have, the better process we have, the better way we can plan for a project to not impact Utah's 13,000 years of human history. And so we've done that in such a way that projects can move forward without deep level concerns and impacting resources without due diligence.
So, thank you very much. I know my time is up, Mr. Chairman. I just want to end on two quick notes. One, I'll submit some questions for the record in writing for the witnesses afterwards. I know some of my colleagues spoke to some of the funding and staffing, general resource concerns, the need for them as opposed to cuts and reductions that we seem to be fending off. I'll ask Mr. Concho specifically about TIPOs and the $100,000 figure. That seems very low nowadays, especially, and the value of additional investment for this process. And lastly, Mr. Chairman, while the conversation has been centered around consultations for specific projects and a project-by-project basis. I know California is not the only state, maybe one of the first states, to grow these relationships and partnerships beyond just consultation for purposes of a specific project, but genuine partnerships, in shared management responsibilities of public lands and stewardship for the long term of public lands. There's a lot of experience and historical knowledge to be gained here, whether it's management, whether it's environmental species protection, whether it's wildfire mitigation, on and on and on. So I hope these are great examples that other states can be inspired by, learn from, and replicate. Thank you, Mr. Chair.
I'm going to just put a sort of fine point on what Senator Padilla mentioned. That a couple of things that we clearly heard in this hearing today is that we need better coordination between federal agencies, and that has been my personal experience, and I think that's something that probably is shared across the aisle. But we also need people at the desks. Like, there are talk of extensive additional layoffs at our public land agencies. I think there is no question that will further slow the certainty that whether you care about this flavor of energy or that flavor of energy, if there's no one at the desk, you can't get a permit. And we need to make sure that's not the case. That is not responsible management. It's not responsible stewardship of our public lands, and hopefully we can find some common ground around that for the entire energy spectrum. Thank you, Chairman.
Thanks. And I appreciate that insight, yet nobody wants to see a process that has resulted in a lot of delays produce even more delays. I will note that these relatively recent efforts within the Trump administration to streamline the federal workforce, it's almost mathematically impossible that those could have caused significant delays that we're talking about here. And I'd add that the examples I mentioned, each of the examples I mentioned in my opening statement have been going on for many years, and that each of them encountered significant delays, either under the Biden administration or the Obama administration. A lot of what we're talking about here today, as we've discussed at length, is the fact that we've got some ambiguous text that has left TIPOs and SHPOs, among others, in the process with a lot of subjective, there's a lot of subjectivity involved in it, and that has resulted in delays. So to the extent that we can clarify those standards, we'll all be better off. I want to also enter into the record a piece by the Washington Post editorial board from a couple of days ago, talking about the ballroom and placing it in a historical context. Those will be admitted without objection. Finally, before we conclude today's hearing, I want to take a moment of personal privilege to recognize our Chief Counsel, Pat McCormick, who will soon be departing, sadly, after 14 years of service to this committee and to the United States Senate. Pat is an extraordinary human being. Anybody who's interacted with him knows that. His mind is an encyclopedia that knows the work of this committee backwards and forwards and upside down. His judgment and his deep knowledge of all the laws touching on the subject matter of the Energy and Natural Resources Committee have anchored this committee's work through many of its most complex and consequential debates over the last decade and a half. We'll be introducing a resolution to honor that service, but for now, Pat, just thank you for your many years of service. Thank you. You're a good man. We wish you the very best of service, best of luck in all of your future endeavors, and thanks for your service. Thank you so much. All right, so that'll conclude today's hearing. Thank my colleagues for their contributions. Thank the witnesses who have traveled great distance to offer great insights today. Any senator who wishes to submit additional questions for the record may do so. The deadline for doing that will be 6 p.m. tomorrow, and that's Thursday, the 30th of October. Senators will have until 6 p.m. next Wednesday, November 5th, to add any statements for the record to today's hearing. Thanks again for being here, and the committee stands adjourned.